Our next presentation is What to Expect When Returning to Work. It is my pleasure to introduce Monica Fawzy Bryant, who is a cancer rights attorney, speaker, and author dedicated to improving access to and availability of quality information on healthcare-related issues. She is the co-founder and chief operating officer for Triage Cancer, a national nonprofit organization that provides education on the practical and legal issues that may impact individuals diagnosed with cancer and their caregivers. Throughout her career, Monica has provided hundreds of educational seminars, written articles, blogs, and co-authored a book published by the American Bar Association called Cancer Rights Law, an interdisciplinary approach. Monica, thank you so much for being with us today, and I know we're all looking forward to your talk.
Thank you so much for having me. So I'm delighted to be here today to talk about cancer, work, and COVID and the strange new world that we are all living in. But because we only have a little bit of time today, I do just want to spend a couple of minutes up front telling you a little bit about my organization so that if after today you still have questions about work and your rights, or you have questions about other topics, you know that we can be a resource for you. So Triage Cancer is a national nonprofit that provides education on all of the practical and legal issues that can arise after a diagnosis, both for the individuals who are diagnosed and also for their caregivers. And we provide this education in a couple of different ways. So we also host free educational events. We do typically 3 conferences a year, which are open to anyone who's interested in learning about these topics. Of course, this year we've gone virtual for the most part. Our next one is going to be on October 3rd, which is virtual. We're holding out hope for our October conference in Chicago, but who knows? We're all being flexible and nimble, right? So if you're interested in learning more about any of these topics, please take a look at the website. We also host monthly webinar series, and these are the next couple that are coming up. And so we talk about things like understanding Medicare and how to make choices and health insurance. And if you've missed any of our webinars or you want to go back and watch something else, we record all of our webinars and they're available for free for watching anytime on our website. Now, because where you live can impact what rights you have access to, we also have charts of state laws. So you'll see me where I point to them today, where we want to be looking at not just the federal laws, but also the state laws as well. And the charts of state laws are a place for you to be able to go and do that. And then we also recognize that people learn in different ways. And so we have a series of animated videos that are anywhere from 4 to 7 minutes, and they're available in English and Spanish. And they're just a starting off point for various topics. So if you don't want to read anything else and you just kind of want to watch a quick video, these might be a great option for you. And then we host an entirely separate website called Cancer Finances. And this site includes information on all of the topics, or many of the topics, that can impact your finances after a cancer diagnosis. But what's unique about this site is that it's sort of built in a choose your own adventure format. So the site poses questions to the user, and then based on the user's answers, it will take them to targeted information, because we know that there's so much, and there's so much to try to understand and navigate, that we don't want people to have to wade through information that isn't relevant to them. And as you see, we should have a module on employment coming up in the next couple of weeks. So we also have what we refer to as quick guides and checklists, and you'll see links in the slides throughout today's presentation about those. And they're designed to just be a snapshot and a starting point, again, for a particular topic, but they're all available for free download on our website at triagecancer.org. So with that as our sort of foundation, and to know that this isn't going to be the only time you're going to be able to access this information, I want to jump right into it. So when we're talking about employment rights, there are several places that we're going to need to look to figure out what we might have access to. There are fair employment laws, both federal and state. These laws are going to be about protecting people from discrimination and also potentially providing a tool called a reasonable accommodation, which we'll do a deeper dive in just a few minutes. There are also leave laws, again, both federal and state. But if you are an employee working under some sort of contract, be it an employment contract, or you're a member of a union and part of a collective bargaining agreement, those contracts may provide different or additional rights and benefits. So very important to also be looking at your specific contract for what rights you have access to. But the reality is the law is the bare minimum of what employers are required to provide. Many employers are much more generous than that bare minimum. And one example of that generosity is if you have access to sick time or vacation time that's paid, most likely that's because your employer is providing that as a benefit, not because they're required to provide that. There's actually very few states that require employers to provide paid sick leave. But other types of benefits or policies you might want to be looking at your specific employer. What types of insurance do you have access to? So often people will come to me and say, I don't have access to disability insurance. I say, well, are you sure? Have you looked at your job? And then they go back and they look and they find out, well, oh, that's what that $5 a month has being taken out of my paycheck was for. I do have a short-term disability policy. So it's always really valuable to go back and look at your specific employer. Also, some employers have processes set up that could make navigating what I'm going to talk about for the rest of the session easier. For example, your employer may have laid out a process for how to ask for medical leave or how to ask for a reasonable accommodation. And if they've already laid out a process, it can in fact be much easier to just follow that process than to try to reinvent the wheel and figure out how to navigate this from scratch. So where do you go to find out what kinds of policies your employer has? It's going to depend. So some employers have a very formalized policy and procedures document or handbook, and you get it in a hard copy when you start your job. Sometimes it's all cloud-based or it's all on a server somewhere and you can access it electronically. Sometimes it's done on a website. Sometimes there is no formalized document. If there isn't a formalized document, then generally the next step would be to ask a coworker if they have any ideas about these issues, or to ask whomever is responsible for things like payroll and benefits. That's going to be the person that should have the answers to these questions, because not every job has a very formal HR department. But really, really critical to be looking at your specific employer as well as the federal and state laws. So the first law I want to talk about today is the Americans with Disabilities Act, or the ADA. This law, many of us are familiar with this law because of accessible parking spots outside of businesses or ramps into stores. But the ADA did some really important things in the employment arena as well. But just like many laws, there are some eligibility requirements or hurdles that you have to clear in order to use the law's protections. So the first is that you have to work for a private employer with or more or a state government of any size. Now, if you are a federal employee, you have very similar rights, except it's not going to be under the ADA, it's going to be under the Rehabilitation Act of 1973, which is very similar to the ADA. So in addition to working for a large enough employer, you have to be a qualified individual, which means you can perform the essential functions of the job with or without a reasonable accommodation. Practically speaking, what that means is you're qualified for the job in question. If you are applying to be a commercial truck driver, you have a commercial driver's license. If you're applying to be an accountant, you have the proper training and license in that state. You're qualified for the job. And then finally, you have a disability under the ADA's definition. Now, typically in presentations, I use the word disability about 100 times or more, but it's important to remember a couple of things. First, I get some pushback from individuals in the cancer community about this word, that they don't feel like they have a disability, they have an illness, which is totally fair, and words do matter, but in this particular instance, I urge people not to get caught up in the language because they could end up missing out on protections. The other piece is we have to remember that each time I talk about disability under a different law, it's going to have a different definition. So specifically under the ADA, the definition of a disability is a physical or mental impairment that substantially limits one or more major life activities. I recognize that's a lot, so let's break it down. You have a physical or mental condition, and that condition is limiting or impacting something called a major life activity, and it's doing so substantially. So what's a major life activity? It's anything that the average person in the general population can do with little or no difficulty. So we're talking about things like walking, talking, eating, operation of major bodily functions. These are all major life activities. Now, when we're in the cancer context, oftentimes it is not the cancer itself that gives rise to the disability, but rather it's the side effects from treatment. And it could be that a side effect is substantially limiting all by itself, or it could be that all of the side effects you're experiencing together is what gives rise to the disability. So once we figured out that somebody is in fact eligible to use the ADA's protections, so they work for a large enough employer, they're a qualified individual, and they have a disability under the ADA's definition, how do you actually use it? There's 4 different ways. The first is that you currently have the disability. So you're in the midst of treatment and you're dealing with severe side effects. The second is that you have a history of having a disability. So maybe you're out of active treatment, but you're still experiencing long or late-term side effects. The third is being regarded as having a disability. So this isn't about you at all, but rather it's about your employer's perception of you. And finally, you may be protected based on your association with a person with a disability. So this is where caregivers might be able to get some protections. Now, what's interesting about the ADA is that it applies to all phases of employment. So through the job search process, all the way through hiring, promotions, benefits, and firing. So what do you actually get? In all of these circumstances, qualified individuals are protected from discrimination, which means employers can't be making employment decisions based on your medical condition. But if you currently have the disability or you have a history of having a disability, in addition to being protected from discrimination, you're also entitled to a thing called reasonable accommodations. But before I get into reasonable accommodations, it's very important to remember we can't just look at the federal laws for our protections. State laws may actually provide more or additional benefits than the federal law does. Can't ever take away benefits from a federal law, but it could provide more. Most states have a state fair employment law, and most of them are very similar to the ADA, but many are more protective. And perhaps one of the most significant ways that it can be more protective is that it covers smaller employers. So this chart shows you the number of employees each employer has to have in the state to be covered by the state fair employment law. So you can see I'm in Illinois right now. If I live in Illinois, then my employer only has to have 1 employee to be covered by the state fair employment law. Now, if you don't see your state here, it just means that it's the same as the federal law and it requires 15 employees. So if you work for a smaller business, the state law might be the thing you're going to. So both the federal and the state laws provide reasonable accommodations, which is any change in the work environment or in the way that things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. Super clear, right? I know. The best way to talk about reasonable accommodations is through some examples, and we can really categorize reasonable accommodations into 3 different categories. The first is about physical space. So perhaps it's about special furniture or moving offices. So if you're dealing with severe nausea, then having your office right next to the office cafeteria where people are microwaving things all day might not be the best place for you. So maybe you can switch offices. It could also be about telecommuting. Now, telecommuting might mean working from home, and I realize that for a lot of us, that is becoming the new normal, but it could also mean working from a different location. So maybe there's a location with fewer people, and that might be important given COVID and the risk of being in larger groups right now. So modifying actual space. The second category is about modifying schedule. So maybe this means instead of full-time, you're going to part-time. Maybe it's a more flexible schedule. So on days that you're getting a treatment, maybe you need to start later in the day. Or if your side effects are most significant in the late afternoon, maybe you can start earlier in the day and end earlier. It could also be about extended leave, which we'll get into in just a minute. And then there are a whole host of other options, like using technology or shifting policies, sometimes even about shifting responsibilities. I was just talking to a woman who works in a large office, and she's a manager, and she could do about 85% of her job from home. And so basically what they did is they shifted that other 15% to another employee, and she took on that employee's work that could be done remotely. So sometimes it's about shifting responsibilities. And then sometimes it's about changing jobs altogether. Now, I get a lot of questions, both from employers and employees, about the cost of accommodations. And there have been studies done to show that most accommodations cost the employer absolutely nothing. And then the rest are usually a pretty nominal fee. But most of the time employers want to provide the accommodations because it helps them retain valued employees. So it really is valuable to remember when you're thinking about accommodations that it is a mutually beneficial situation. Now, if your employer is bound by the ADA and you are a qualified individual, the employers have to provide you with an accommodation, unless they can show that it's an undue hardship or a direct threat. And the exact definitions of undue hardship and direct threat are going to be very specific to the employer and the job, but it is a very high bar for the employer to meet to say that something is an undue hardship. But it does have to be reasonable. So if somebody is a bus driver, telecommuting probably isn't going to be reasonable for that specific job. The other great thing about reasonable accommodations is it's not one time you got your one check, you're done for the year. You can have more than one to deal with the multiple side effects. So maybe you need to move your office away from the cafeteria and you need to have a flexible schedule. Reasonable accommodations are one of the most valuable tools, in my opinion, for individuals who are trying to work through treatment or who are experiencing late or long-term side effects. And so to that end, we've created several resources that might be useful, including a quick guide and a checklist, as well as one of our animated videos. Now, under the law, caregivers are not legally entitled to reasonable accommodations, but most of the time it falls into one of those it can't hurt to ask situations, because just like I mentioned with employees, employers want to keep valuable employees. So it may not matter to the employer if it's the employee is the one that has cancer or the employee is the caregiver. And this is particularly important right now when we're in this situation of caregivers being concerned about going back to work as states are reopening and potentially infecting their loved ones with compromised immune systems. So this is just some detail and some tips about asking for reasonable accommodations. Generally speaking, you're going to want to ask for one as soon as you realize you need it, because if your job performance starts to suffer and the employer doesn't realize why, they can make a decision like a firing or a demotion based on that suffering job performance. So valuable to really check in with your employer as soon as you realize you need one. Now, your needs may change over time. So what you need in the midst of active treatment is probably going to be different from what you need 6 months out, 5 years out. But employers do need to engage in what's called the interactive process, which is basically a fancy term for a back and forth conversation between the employer and the employee to come up with the best reasonable accommodation for everybody. Now, the FMLA, or the Family Medical Leave Act, is a federal law that is for an individual with their own serious medical condition or an individual who is caring for a seriously ill child, parent, or spouse. Most of the time when people hear me speak for the first time, they're pretty surprised at how narrow that definition of family is, and it is pretty narrow. Now, I could spend an entire hour just talking about FMLA, and obviously we don't have that today, but do know that we have some webinars on taking time off and how to pay for it, as well as a recently released extended quick guide available on our website that goes into the details of how to become eligible for the FMLA. But I did specifically want to talk about some of the new laws that have come out in the last couple of months as a specific response to COVID-19 or coronavirus. So the Family First Coronavirus Response Act is a new option to take sick leave. And it is actually an expansion of the FMLA, because the FMLA is unpaid leave, and under Families First, it's actually paid leave. So there's a significant difference there. But it is narrow in terms of its reasons for taking time off. So this chart actually shows you the qualifying reasons that someone might be able to take time off for sick leave, and then the various amounts that someone might get paid. But I did want to show this today, even though we can't do a deep dive into all of these different reasons, is we're getting a lot of questions about this one that says self-quarantining. The law, when it refers to self-quarantining as a reason for paid sick leave, is not about somebody self-quarantining because they are concerned about contracting coronavirus. It's about self-quarantining so that because they think they might have it or they could have it, and they don't want to expose others. So that's a very important distinction and understanding of this particular law. Now, the other new provision is about paid FMLA. So this is about taking time off as a caregiver, and it's for one specific reason. And that is if the person cannot work or telework because they have to care for a minor child, if that child's school or place of childcare, like a daycare, is closed or provider childcare isn't available due to COVID. So it's pretty limited. And what is interesting about it is that while it's 12 weeks of job protected and health insurance protected leave, like the FMLA, the first 2 weeks are unpaid. The next 10 weeks are paid, but at a portion of the regular salary. But where it was very confusing for a lot of people, and it still is, frankly, is that this is really just a new reason to take leave under the FMLA. It's not more weeks. So when it first came out, people thought maybe we could string this together with the FMLA and actually end up with 24 weeks off, but that's not in fact what happened. So I recognize that that was incredibly fast, and you probably have a ton of questions, but I did just want to point you to a couple of resources. So we have now presented 2 that are on our website for watching, specifically related to insurance, finances, and work during COVID. We also have a blog that we just released about options for returning to work safely for people who are concerned that they're immunocompromised on our blog. And it's for both individuals who have the compromised immune system and also for caregivers who may be concerned about their loved one. And stay tuned, because we are planning a 3rd webinar specifically on these issues. We're actually just waiting to see if Congress is going to release another package so that we can try to give people the most up-to-date information. So I just wanted to leave you with Thomas. He's a nurse at a local hospital. He's been working through treatment. The hospital says he's going to now be reassigned to a COVID unit. He's concerned about exposure. What are his options? And this has been a really common question lately, and not just at hospitals, but the laws and the protections are basically what we've talked about today. So first, Thomas has to consider, does he want to actually take time off and not work? Then we're looking at FMLA or state laws, state leave laws. Maybe he's asking for a change to not go to the COVID unit. And so that would be an ADA, reasonable accommodation request. Most people that are going through cancer treatment are going to have a compromised immune system, at least for a period of time. So a request to telecommute may not be unreasonable or unusual. But the challenge right now is because of the uncertainty and all of the unknowns around COVID, what might be considered reasonable right now might not be reasonable come the fall. And courts have found that attendance is an essential job function. So all of this is to say, and I recognize it's frustrating probably to many of you listening, we're in uncharted waters and the landscape is changing day by day. More and more employers are having their employees work from home to prevent community spread. But then there are some states that are reopening faster than others. And so what might be reasonable for a person in one state might not be reasonable for a person in another state. So I just wanted to kind of bring that up and mention that I may not have concrete answers for you because there may not be concrete answers to give right now. But when thinking about accommodations, which again, I think is a really valuable tool, even outside of a COVID environment, this is sort of the checklist that we suggest people think through. And also think through the idea that they may not have to disclose their specific cancer diagnosis if they don't want to. And while you might have to disclose some information in order to access these benefits, deciding what you want to keep private and what you want to share with your employer and your coworkers and whomever else is important because it can have a really long lasting impact on several areas of your life. And we just really want people to be thinking through the disclosure piece because it's hard to put that cat back in the bag. And of course we have resources on these issues as well. So that's the content that I have for you today. I'm gonna leave this up just for a minute, but I'm happy to take questions if there are any. Well, thank you very much, Chester. Chester saying that Triage Cancer is an amazing resource. I certainly hope so. And if you are on our website and you're looking for information that you can't find, please feel free to always reach out to us. There's some contact information and how you can connect with us. Could I please repost the checklist? So there you go. There is the checklist. Sorry, I'm just reading through one of the questions. Okay, for cancer patients who feel that a particular workplace isn't safe to return to because of COVID-19 considerations, what should they check first? Sample other workers not wearing masks or maintain a 6-foot difference. You know, I think that, again, there's not going to be a one size fits all with any of this. I certainly think that the recommendations coming out of the CDC and many state departments of health is that wearing masks and maintaining a 6-foot difference and not gathering in groups of, I think it's larger than 10 right now. That number seems to be fluctuating based on the day. Those are all really important things. But I also think that there would be a really valid reason to be thinking about, would a reasonable accommodation be valuable or necessary for that particular person? So maybe is there a different office they can work from, or if they work on, I don't know, a construction site where they used to be in a place where there were lots of people working in close quarters, is there somewhere else on that site that they can go work, maybe an outside post? So it's really hard to answer these questions in the abstract, but I think that looking at the reasonable accommodations is really important, but then also expressing to the employer the concerns that given the compromised immune system, that your concerns are above and beyond perhaps the rest of us. And so are there things that you can do to make it a little bit safer for you? And then in some situations, there might not be a reasonable accommodation, and then someone's gonna have to think about the taking time off type options. So I hope that answered the question.
Monica, thank you so much for this wonderful and informative presentation. It's just been so helpful, I think, to so many of us. I learned a lot, so thank you.
I'm so glad. Well, thank you so much for having me. And I certainly hope that you all will have a continued relationship with Triage Cancer and a great rest.
Yes, we look forward to it. Thank you.